a lot of community facilities seek to vest their rights on what they could develop. One of those community facilities happened to be New Testament. New Testament submitted to the town a site plan. Russell, do you have that site plan queued up?
Yes, sir.
Just for the general public, if anyone wants to see it. So New Testament submits this site plan to the town. And as you can see, it's a full build out of their property of approximately 931,095 square feet of community facility uses. In this site plan, they have, including in their field, they have residential, which we told them wasn't allowed, so they said it was ALF, which is allowed under community facility. It has expanded school, classrooms, meeting rooms, entrance gathering halls. It is probably one of the largest community facility projects that you would find in this area. This is what they submitted. No one can't forget this. This is what occurred in 2000, I think it was 16, which is what they said they wanted to build in the ranches. So I want to make sure everyone realizes that. So despite the fact that this was their site plan and they were represented at that time by Berger Singerman and a former Cooper City Commissioner named Russell Setti, and they proposed this development in the town, and the residents in the area went crazy. They said, we don't want this. We need to stand firm and adopt our regulation to prevent this from occurring. The town council unanimously approved the second reading of the zoning change to reduce the amount of overall square footage that any community facility could build. When they did that, just by way of New Testament only, because it affected all of them, they went from 931,095 square feet of buildable area to a reduced number of exactly, it's 308,000 and change, approximately 309,000 square feet of buildable area. So we reduced their overall building area by 600,000 square feet, okay? Huge reduction, okay? Huge, huge reduction. The amount of traffic associated with that is, you know, enormous. So what happened after that? New Testament immediately filed litigation against the town. They hired an attorney named David Mancuda and a whole other slew of attorneys, and they started litigation against the town. Basically, their point was, under the Byrd-Harris Act, very simple. You can reduce us by 600,000 square feet, but you have to pay for the reduction. That's what it told the town, which would be an enormous sum of money for anyone who knows about development and development footprints. Instead of agreeing to pay New Testament for the reduction, the council met with them in numerous public meetings. In fact, you know, I heard Councilmember Hartman mention it before. It was discussed at the April 14th, 2016 meeting. It was discussed at the August 25th, 2016 council meeting. It was never discussed in the shade. There was never a shade session. Instead, it was meeting after meeting before the council. And finally, on October 13th, 2016, a settlement agreement was brought before the council and was debated at length, in which the council agreed to transition their vacant property, their 40-acre plus vacant property, to rural estates to allow them to get back the financial amount of their investment, which would enable them to have 1-acre lots. But I drafted the settlement agreement. They didn't. So I did put a clause in that settlement agreement that was clear. And it said, if you do not come forward within 1 year, essentially 120 days, but it was basically 1 year, of the time that we approve this, that portion of the settlement agreement is null and void, and you do not get your 1-acre lots as of right. It's no longer as of right. Well, guess what? They didn't come forward. And as such, they lost their automatic opportunity to get 1-acre lots on that property. But I just want everyone to know that, you know, today, it's community facility. Today, as of right, they could build another 309,000 square feet. That would mean their total cumulative square footage on that property would be equivalent to very close to Cypress Bay High School. It would be very close to the size of Cypress Bay High School to be built on that property. The traffic would be enormous, you know, if it ever got to that capacity. So, although this item is not before you, I wanted to give you all a historical background to show where we are, okay? But we are at an even playing field right now. At some point, the residents will have to make a decision on whether or not they support their property right, which is what they're allowed to do as of right, which is 309,000 additional square feet of, or total square feet of community facility.
That we can't do anything about right now.
That's as of right. Or whether or not the community wishes to make a deal with the property owner to enable them to sell it. You know, and that's something that will have to be decided by the greater public and the council in the future. Today, it's an equal playing field. There's nothing as of right on that property except for the reduced amount of total square footage that they can build there. So the settlement agreement did exactly what it was supposed to do. It reduced their overall development footprint and doesn't give them anything but that reduced development footprint. So that's the basis of the New Testament settlement, where it stands, and why today you can do whatever you want concerning the future of that property. Before I move on to the next issue, does anyone have any questions about New Testament? I meant the council, but it's up to the mayor if he wishes.
David,
Yeah.
go ahead. You can.
Thank you. David said good job. That was the best question I've ever got. Any other questions about New Testament? Okay.
No.
Seeing none, let me see my notes. Is there anything else I need to speak about? Nope, that is all. I'm going to go over to.
Any litigation with Pembroke Pines?
Oh, yeah, you know, the litigation with Pembroke Pines is virtually at a standstill because CCA is still in the Court of Appeals with Pembroke Pines. The only litigation that has reared its head is the Layfield litigation. And just to remind the public what that is, a gentleman who's on the list of being a sexual offender desires to live in a portion of the town which we believe is not legal because of the location of a school bus stop to that location. And as such, he has challenged the legality of our ordinance that restricts him from being in close proximity to a school bus stop. So that litigation is going forward. We filed the motion to dismiss, but they're litigating that one pretty hard. So other than that, Mayor, thank you for the time, and everyone stay safe.
Awesome. Thank you, Keith. Greatly appreciated. And Mr. Burns.
Yeah, thank you, Mayor. Just a few things very briefly. But first, I do want to commend Russell and Full Moon, our consultants, because we weren't sure how tonight was going to go, doing a virtual and live meeting hybrid like this. So the fact that we've been able to pull it off is certainly a testament to their efforts and their preparation. I want to thank them for that.
Thank you, gentlemen.
The Councilmember Hartman had asked me for an update on nursery ordinance, and I had put that on hold. And the reason I put that on hold is, as you all recall, there was a lot of community concern and a lot of community input over that. There were a lot of discussions. We spent a lot of time on it. I think we had reached, in February or March, we had reached a point where I think we had incorporated all the residents' concerns, all the council members' concerns, and I really think we had it done. But at that point, we stopped having public meetings, and I put it on hold because I didn't want to create a situation with the residents where we were potentially trying to put an ordinance through under cover of darkness. You know, there are a lot of people who came out for those public meetings, had a lot of input in the process. We respected that, we honored that, but what I was trying to do was hold it until we went back and met in person again, without knowing what the schedule was going to be. Recognizing that COVID cases are on the increase. We're up to 20 in town right now. As you said before, Mayor, the governor has extended his executive order allowing us to have virtual meetings. It's my anticipation that both meetings during the month of July will be virtual, but I will bring that nursery ordinance through again.
At some point.
And no, we'll schedule it for first reading at the second meeting in July. I think it's ripe. It's ready for your consideration. But we'll make sure the public knows it's out there, and we'll promote that meeting agenda appropriately. I think Councilmember Hartman also asked about the CCA site. We are finalizing that agreement. We're ready to give it to the other side for their consideration.